The recording has commenced.
Thank you.
Okay, ladies and gents, let's continue then. The recording has started. Now, if there is no sort of constraint on what we may do in our wills, there is, however, a difference between a valid will and an invalid will. And maybe just a tip from my side, I think it's going to be very helpful if you sit with a pen and paper and take down some notes while we're doing this. So I'm obviously focusing on things I deem very important going forward, and I'm pretty sure those notes will assist all of you in the process. So we say in South Africa that testate law is when you die with a valid will. And I think that term valid is important. So what makes a will valid or invalid? In other words, what are the formalities or the requirements for a valid will? Number one, first and foremost, which I think is quite an obvious one to all of us, a will needs to be in writing. I think we're all quite aware of that. We cannot have any oral wills. It has to be in writing for it to be valid. Now, this will also needs to be signed by the testator. I think we are also well aware of that as well. The will needs to be signed by the testator. Now, in South Africa, what's required is that the testator initials every page and signs in full on the last page. I think from contractual law, we should be well aware of this anyways. I mean, contracts are anyway signed sort of on each page. And the reasons there too, I think, speaks for itself. But this formality goes further. It's not just about the testator signing the will on each page, but it goes further to say that the will needs to be signed in the presence of two competent witnesses. I'll say that again. The testator needs to sign the will in the presence of two competent witnesses. And vice versa applies there as well. If the testator is signing the will in front of two competent witnesses, these two competent witnesses need to sign in front of the testator. So the testator and witnesses are signing in each other's presence. That is important for a will to be valid. Now just to stop on that theory, and in case we're wondering, I mean, it goes without saying, I'm sure a lot of people who sign as witnesses have no idea what's going on in that document. And I think that's besides the point. The reason why we have the testator and witnesses signing in each other's presence is to prevent fraud. And I think it goes without saying to think if someone questions the validity of a will, the first thing the court would do is they would call the two witnesses in who signed to confirm, did they see the testator sign in their presence? If the answer is yes, then I mean, we have a valid will. If the answer is no, we have an invalid will. So it's very important to avoid any long-term possible issues to ensure that the testator and witnesses are signing in one another's presence. Interesting though, the witnesses do not need to sign every page. These two witnesses only need to sign the last page. Now, you know, I won't lie to you. In my office, I get the witnesses to sign every page. But by me doing that, it does not make the will more valid or invalid. The question is, what is the requirements for a formal valid will? And the requirements is that the witnesses must sign in the testator's presence and vice versa. But these witnesses only need to sign on the last page, where the testator will need to append a signature to every single page of that will. Now, on the face of it, that is your basic requirements for a will to be valid. The content thereof is totally up to that individual. We have freedom of testation. But I feel that we can take those requirements a bit further, because you might come across in your lifetime as an attorney dealing with deceased estates and wills that not every person is capable of signing their own will. I mean, there might be some other problem, physical impairment with this individual, or perhaps they lack control of their bodily movements and motions at a certain stage when they are attending to their will. In other words, What happens if someone signs a will on someone else's behalf, or you sign by making a mark? You know, I remember a client a couple of years ago who I went to go do her will, and she couldn't control her hand at that specific stage. It was shaking too much. So she literally signed by making an X at that point of view. She was mentally sound of mind, but she didn't have control over bodily movements. So she signed by making some sort of mark on the will, or she could have got someone else to sign on her behalf. So the question is, what happens if someone signs on your behalf? Or what happens if you sign by making a mark? How is that will valid? Well, quite easily. The moment someone signs by making a mark or someone signs on their behalf, that will need to be commissioned by a commission of oaths. So a commission of oaths will need to come in, commission that will, and will have to say the following two things. These are very important. On the will, they will need to indicate, number one, they are satisfied with the identity of the testator. So number one, they are satisfied with the identity of the testator. And number two, this is indeed the true will of the testator. So secondly, this is indeed the true will of the testator. All right. So long and the short, if we look at our requirements, nice and easy, must be in writing, signed by the testator on each page, signed by two competent witnesses only on the last page, but importantly, the testator and witnesses need to sign in each other's presence. And then we took the formalities one step further and said if someone signs by making a mark or someone else signs on their behalf, that will needs to be commissioned by a commission of oaths and needs to indicate on the will two things. Firstly, satisfied with the identity of the testator, and secondly, that this is indeed the true will of the testator. Once we have satisfied those requirements, ladies and gents, you now have a formal valid will. Once you have a formal valid will, like I said, there's no right or wrong. I think there's the differences only comes in between good or bad. You can have a good will and you can have a bad will. A good will, I think, is a will where once read out, it can't really be challenged and it leaves no gray areas. And there's a proper understanding to what should happen. And we cannot fight, or the beneficiaries can't fight over certain things in a will. Where a bad will is more of a vague will. And I think the more knowledge you have on common law with regards to testate law, the better you are equipped to ensure you do not have a bad will at the end of the day. Now, in our formalities, we spoke of a testator or testatrix. So the question is, how old must you be before you can make a will? Easy answer, 16 years of age. You can be 16 years of age and mentally sound of mind, and you can create your own will. We also spoke about two competent witnesses that need to witness this will. To be a competent witness, you must be 14 years of age and mentally sound of mind. So 14 years of age and mentally sound of mind. Ladies and gents, just another reminder, just to make sure we are all muted at this stage. Now and then I'm still picking up a sound, but it is definitely much better. Right. Okay. So ladies and gents, let's move on and look at a couple other different interesting factors about a will. Now, I mentioned for you to be good at drafting a will, you've got to understand some basic law with regards to a will. So just a couple sections that I think is relevant. I think of the Wills Act, obviously in testate law, we are referring to the Wills Act. And section 2A, 2B, and 2C of the Wills Act, I think is definitely worth mentioning. Now, section 2A deals with revocation. To revoke a will means to cancel a will. Now, how do we go about revoking or canceling a will? Ladies and gents, just make sure we are muted, please.
Mr. Kitswan, you
Yeah.
can mute everyone because you are a presenter. So you can mute them under people and then just mute all participants.
So as far as I'm aware, it is just Zukiswa who can mute on this group.
Can Olga switch off her camera because of it's draining our networks?
Okay, but the sound is much better now. All right, ladies and gents, let's carry on. All right, so section 2A, we speak about revoking a will. Now, the easiest way to revoke or cancel a will, ladies and gents, is simply by creating a new will that has a revocation clause in it. Now, to put it in perspective, every will that I would draft for someone, I would literally start the will off with a revocation clause that says, I revoke all previous wills. Now, it obviously goes without saying that if you pass away with more than one will, things could get a bit complicated in winding up that deceased estate. You know, it's obviously highly inadvisable to have more than one will. You should have one final will that dictates how things should be devolved when you pass away. So during the course of your lifetime, obviously your personal circumstances and situations might change, and you would need to update or amend your will as time goes on. So every time you create a new will, importantly indicate that you cancel your previous wills. That's the safest way to go about doing things. And ladies and gents, even if that person comes to you and says to you, this is their first will, I still advise that you have a revocation clause that cancels any potential previous wills. I can tell you from experience, I have dealt with people who had wills who did not even know they had wills. Right? So rather to be safe, you create a will, revoke the other wills. Obviously, the High Court has the power to deem a will revoked as well. On saying that, I can tell you the High Court is the only court in South Africa with jurisdiction to deal with any disputes about a will. And thirdly, the rule says that a will is deemed revoked if it has been destroyed. A will is deemed revoked if it has been destroyed. Now, to say a will is destroyed would literally mean you can't find the will. And that's exactly it. If we know X has a will, but when X dies, we cannot find his or her will, it means the assumption in our law is that X did not want us to find his or her will. In other words, X has destroyed their will. So there's your three meanings or three ways to revoke or cancel a will. Simply create a new will, the revocation clause, or secondly, dispute it in the High Court and the High Court revokes it, or thirdly, just make sure no one can ever find that will. Your will then be revoked. That was section 2A. We said we want to look at 2B and 2C as well. So let's think of section 2B now. Now, 2B is a very interesting section, and I want us to all understand this right from the get-go. What I'm speaking to you about is common law. Common law is the law that applies when our will is silent. I think that's a very important phrase. The law that applies when our will is silent. What I am trying to tell you is that all these things we're speaking about now and these different aspects of the Wills Act, they don't have to be that way. If your will says something differently, we will follow what your will says. Common law, you can overwrite common law at any stage. But the key thing is, if you don't know common law, then you won't know what to overwrite. You won't know what to amend. And then things will happen based on common law assumptions. So how do you make a good will? Know what common law is and explain the common law aspects to your client. And let your client decide if they are happy with that or not. If they are not happy with certain aspects of common law, amend it in the will. You can amend common law legally in your will. So section 2B is an example of a common law clause that I don't know how many people would be too satisfied with. So section 2B deals with a 3-month sort of rule. Okay, so let me talk about it and you can make your note as you wish. So let's talk about the assumption in our law. Now, there's an assumption that if you are married to someone, there's probably a good chance that person forms part of your will. The assumption goes further to say if you divorce that individual, there's probably a good chance you no longer want that person to form part of your will. Okay, now that's probably 2 fair assumptions, I would say. But the rule then qualifies itself. It says that if you and your spouse divorce, now when I say divorce, I literally mean the day you're in court and the decree of divorce is issued. It says if you and your spouse divorce and you die within 3 months, so within 3 months from date of divorce, the assumption is you no longer wanted your spouse to inherit. So your spouse would automatically be excluded from your will, right? Because the assumption is when you were married, your spouse was part of your will. And then you died within 3 months from date of divorce, maybe you haven't had enough chance to amend your will. So your spouse will automatically be excluded. But if you die 3 months after date of divorce, the assumption now is you have had enough opportunity to amend your will. So it is clear that you still want your spouse to inherit should you not have amended. Okay, so just to repeat that's a very important aspect of our law. Deals with the 3-month rule after date of divorce. Now, ladies and gents, again, if you divorce or you're on the process of divorcing or the day after you divorce, you can go amend your will and do what you want. I'm referring to people now who do not amend their will when they divorce. The assumption is if you divorce and you die within 3 months of the date of divorce, you have not had enough chance to amend your will. And the assumption then is that you no longer actually want your spouse to inherit, should they have formed part of your will whilst you were married. However, if you die 3 months after date of decree of divorce, the assumption is you have had enough chance to amend your will. And if you have not excluded your spouse from the will, then the assumption is you actually still want your spouse to inherit. It's a very important aspect of our law. Now, ladies and gents, there's probably a good chance if you explain that law to your client, they might not be happy with it. They might want to adjust it. They might feel, listen, if my will says something, follow the will. Don't make assumptions, or whatever the case may be. But no one ever speaks about this because no one understands and knows the law or takes the time to explain that to their client. So mention that to your client. If your client is happy with section 2B of the Wills Act, then say nothing because it's common law. It automatically applies. And if your client has an issue with section 2B, then you need to address it in your will and specifically indicate in your will that section 2B will not apply and indicate what will happen should your client and their spouse divorce. All right. So importantly, we could not have done this if we didn't understand what 2B is. Right? Let's look at 2C. 2C is the other one I wanted to discuss with you. Now, section 2C is also another couple assumptions. 2 specific assumptions I want to speak about, again, under common law. The one assumption deals with what happens when a beneficiary to a will repudiates his or her claim. Okay, what happens when a beneficiary to the will repudiates his or her claim? Now, ladies and gents, to repudiate means you do not want your inheritance. Okay, so in case we were not aware, if someone has left you something in their will, it is not automatically yours. You must first accept it. Okay, in law, when we accept, we say 88. Some people do not accept the inheritance for whatever personal reason they might have, so they decline the inheritance, they repudiate it. Now, in our South African law, the common law assumption is that if someone repudiates their inheritance, the deceased surviving spouse will take that portion. I'll say that again. If any person repudiates their inheritance, that specific inheritance to that specific person will then go to the deceased person's surviving spouse. Important to make that note. Again, this is common law. So if you say no to your inheritance, the surviving spouse of the deceased will get the inheritance. That is the one assumption. The other assumption is what happens if someone is predeceased or disqualified from inheriting. So the second assumption deals with people who are predeceased or disqualified from inheriting. So, ladies and gents, if you're predeceased, it means you died before the testator died. So perhaps in my will, I said when I die, John must receive 100,000 rand. But then John goes and dies, and I never go and update my will. John still forms part of my will when I die. However, John has died before me. Okay, so John is predeceased. Or John is disqualified from inheriting. Why would John be disqualified from inheriting from me? Maybe John went and murdered me, right? Great example of when someone would be disqualified. Okay, so if someone is predeceased or someone is disqualified from inheriting, the common law rule is, or assumption is, their inheritance must go to their direct descendants. I'll say that again. If someone is predeceased or disqualified from inheriting, their inheritance must go to their direct descendants. In other words, their children. Okay. In law, we use the word per stirps. S-T-I-R-P-E-S. Per stirps means downwards to your children, if you think of a family tree. Again, that is the assumption. So again, ladies and gents, and this doesn't apply to anyone specifically, this applies to everyone, right? You repudiate, your surviving spouse gets it, the deceased surviving spouse. If you're predeceased or disqualified, your children get it. That person who's predeceased or disqualified, their children get the inheritance. Now, again, we should be explaining this to our client. Telling our client that's what's going to happen, just by the way, in terms of common law. Maybe they don't like it. I'm sure you might have come across wills in the past where someone says, if that person can't inherit, then that person must take it. And if that person can't inherit, then that person must take it. This is an example of a way of people excluding Section 2C. If you don't like Section 2C, mention in your will that it will not apply and indicate substitute beneficiaries if a beneficiary cannot inherit for whatever purpose is given forth. Okay, so again, Section 2B and Section 2C deals with common law assumptions. If you don't like it, amend it in your will. But you need to explain it to your client. As a good lawyer, you explain it to your client to ensure that your client literally has the will and their wishes jotted down the way they want it, and not in the way the South African common law applies. Right. Now, let's talk about a couple other aspects, that stand out in our law that I think is quite important. Now, first of all, adopted children. I think it's important that we all note, and I'm sure we are aware of it. If you are adopted, you are regarded as the child of your adopted parents. The moment you're adopted, you lose all relations to your biological parents. Right? So adopted children are seen or deemed to be the legitimate children of their adopted parents. Okay. No one is excluded in our South African law. What I mean is, if you are illegitimately born or born from an incestuous relationship or whatever the case may be, nothing prevents you from inheriting, right? And the rule regarding adoption is actually there for the adopted children's benefit, right? So they do form part, in essence, of a family tree, but of the family tree of their adopted parents. Now, I mentioned a little earlier that people could be disqualified from inheriting. So in essence, when are we disqualified from inheriting? Now, there's two big aspects of our law that stands out as to why we could be disqualified from inheriting. The first one I've already mentioned. Obviously, when you have murdered the testator, I mean, that goes without saying, you would be disqualified. Now, the second aspect, which is quite interesting because it has sort of been amended over time in our law, but the second aspect of disqualification is when you draft someone's will or when you witness to someone's will. So if you are a witness to someone's will or the author of someone's will, you are not allowed to inherit according to common law. Now, on the face of it, we can think to ourselves, but okay, why does this law exist? Well, on the face of it, it exists because we're trying to prevent fraud or undue influence. I mean, we're thinking if someone is drafting your will or witnessing your will, there's a good chance they could unduly influence you, to ensure they get something from the will. And that's why they're trying to cut it out. But, the problem we have is not everyone knows this. There has been cases in the past, and, because not everyone goes to a lawyer or to a bank to do their will. Some people literally write their wills at home. And it is what it is. And they obviously don't know this common law rules, so they can get burnt by doing things like this. I remember, just in a short background, there was this lady who had a couple brothers, and they all lived with their mom. And when everyone turned 18, they left. Well, when I say they, I mean the brothers left, and she stayed at home with her mother. And her mother got old, and she actually looked after her mother. And her brothers, in other words, her mother's sons, never ever came back home, and, to the point that they completely lost contact. And the mother only had contact with her daughter. And before the mother passed away, she did a will. And in the will, she left her house, which was pretty much her only property, to her daughter. Now, this mother passed away eventually, and when she passed away, all of a sudden, her two sons are back in the picture. They want to know what's there for them. In other words, it's typically we find things like this when there's money or something to gain. People would come back to see what they're going to get. I mean, that's unfortunately the case. And the daughter said, no, mom's made a will, and I'm the one getting the house. You guys have not been present. You haven't, looked after mom. You've just left, and we haven't seen you again. So mom left nothing for you. And these brothers actually went and saw an attorney, and they said, but how did their mother make a will? Because their mother was illiterate. The mother couldn't write. So they looked into it, and they saw their sister, the daughter of the mother, actually drafted this will for the mother. It was the mother's signature, but the daughter drafted it. So they took their sister to court and said, well, she's disqualified from inheriting the house because under common law, you cannot inherit because you are the author of someone else's will. Now, from what we know the sister's in trouble currently because she is disqualified, But she fought it in court, and she said, hold on, I didn't unduly influence my mother. I did not commit fraud. I did not know the rules. Otherwise, we wouldn't have done it. And I can present to you circumstantial evidence that will show you that it is indeed the case that my mother wanted me to gain the house. She doesn't even know her two sons. They're just back because of the money now, all of a sudden. The court heard everyone's evidence, and the court actually said, you know what? I'm satisfied that there was no fraud. I'm satisfied that you did not unduly influence your mother. I'm satisfied that that is what your mother actually wanted. However, the problem is that according to South African law, you are disqualified. But what I'm going to do is I'm going to amend the law. And I'm going to say that if someone can prove they didn't unduly influence that individual and there was no fraud involved, then I will allow you to inherit, but not more than what you would have received intestate. That's very important. I will allow you to inherit, but not more than what you would have received intestate. Now, we'll come to an intestate law tomorrow night. We'll start chatting about it. But just to jump ahead, intestate law meant that the sister and the brothers would share in the deceased estate. So what happened? Let's say she had 2 brothers. It means she got 1/3 of the house instead of the whole house. Now you might look at it and say, but that's so unfair. I mean, clearly the mother wanted to give it to the daughter and she deserved it. But the reality is the daughter should have got nothing under South African law. But because she could prove no undue influence and could prove no fraud and could prove that's what her mother actually wanted to do, the courts allowed her to receive what she would have got intestate. And like I say, without jumping ahead, that is 1/3 of the estate, according to her situation. Right? Every situation differs. But I think it's important we understand that with disqualification, okay? And it could pop up in the exam. I mean, they could give you different sort of factual scenarios, and you need to understand how that rule is sort of qualified in South Africa. Very important. Okay. Ladies and gents, I will open the floor in about 10 more minutes for a couple questions up to date. Let's just handle 1 or 2 other aspects. Another important aspect in South African law that I want to chat to you about is situation regarding housing. You would often find that most people, outside of policies and things like that, people's biggest asset is the immovable property, is their home. You know, we've got to be so careful with how we distribute our immovable property or our homes as such. You know, I cannot tell you how many times I've seen issues over immovable property. Just to give you a scenario, I think, Mavandaba, I think you just need to mute yourself, please. Getting some noise over there. There we go. Thank you very much. And then the other one is Tabang. There we go. Thank you very much. All right. So back to my discussion about, you know, how to view things. And I speak to you about these things, ladies and gents, because, you know, dealing with someone's will, it's being an attorney, but it's also thinking about things that they might not necessarily think about. All right. This is family law. Family law is half lawyering, half emotional. So you've got to think about things with them, because not everyone understands long-term consequences. To put it in perspective, if you leave behind an immovable property to, let's say, your 3 or 4 children, what's going to happen when you pass away? Let's say it's to your 4 children. They're going to acquire your immovable property. One's going to say, let's sell it and divide the money. 2 are going to say, let's rent it out and share the money on a monthly basis. And another one's going to say, no, hell, let's live in it. I'm going to go live in that property. Now, the other 3 don't want to live in the property with the 4th one. But in reality, can that property ever be sold or leased out? It cannot, because you need all 4 owners' signature. So you might have one child benefiting, but the rest not. You know, so usually when we structure a will, and if we leave an asset to more than one person, you know, a nice way to going about that asset is to indicate in the will that, you know, listen, the asset is left to these people. Tinus Galdenhuys, we can just mute over there. So, thank you. So, in such a scenario, what I've seen often quite works is if we leave property to more than one person, we can qualify it by saying that, you know, if you cannot reach an arrangement or an agreement within, let's say, a 12-month period over what you're going to do with this immovable property, then it has to be sold, right? And the money must be divided between the 4, or it has to be leased and the money divided, or whatever the case may be. What are we trying to achieve there? We've got a scenario where 4 individuals are going to get a house, and there is a great possibility that they are not going to agree on what to do with it, and there's going to be fighting about it. So we're trying to avoid any issues like that. and qualifying what can happen there too. You know, if you move over to something like agricultural property, you know, like farming land, interestingly there, according to law, you cannot leave agricultural land to more than one person. It's against the law. It goes on to say agricultural property cannot be left to more than one individual unless you obtain consent from the minister. Now, ladies and gents, that is no game. To get consent from the minister is a long story. You know, I know of people who's been waiting years on consent in that regard. So I wouldn't necessarily walk down that path. You know, and the question then comes, what do we do? How do we leave property? How do we have more than one child, for example, and want to leave this property to more than one person? You know, so I think the answer is quite simple if you move into it. It requires just a bit of thinking. When it comes to your normal residential property, yeah, leave it to more than one person, but create rules. When it comes to agricultural property, you know, I don't think it's the way to go to leave it to more than one person and try to get consent from the minister, because you might never get that consent, you know. So if we can't leave it to more than one institution or person in agricultural property, maybe we should look at putting that property in a trust, you know, or in a company, and then make whoever you want the shareholders of that company or the beneficiaries and trustees of that trust. I think that's the easiest way to go about it. You know, often people with assets of value wish to leave things behind to multiple people. And it becomes difficult when that asset of value is land to leave it to more than one individual. So leaving it in a company's name or in a trust is a good way about going about it. And, you know, some people might be thinking, what about a usufruct? I'm sure we've all heard that term, usufruct. I think in varsity they speak of the right to use something or to bear the fruits of something, but you know, no one ever speaks to you about what that actually means. And perhaps there's value in me discussing that with you, because it's a bit more complicated than just the right to use something. Be very careful when giving someone a usufruct. It could possibly be a very dangerous thing. Let me explain myself. So when you give someone the right to use something, that right is not quantified in our law. It is an unlimited right to use something. Right? So let's make an example out of this. Let's say you have agricultural land. Let's make it a farming land. And perhaps you're farming with cattle over there, and you've got a couple kraals, and you pass away and you leave. You want to leave it to your 2 sons or 2 daughters or whatever the case may be. Let's call it your 2 children. And you find out, listen, we can't leave it to more than one person. So a lot of people's options is then, hold on, let's leave it to the one and give a usufruct to the other, because it's not about the living, it's about the actual ability to earn an income from this agricultural land that we're trying to leave to them. You know, and the one we give a usufruct to, maybe we can give them a couple other things to try and make up for it. You know, this is often the way people think. Now, let's analyze this. Let's say child A gets the farm and child B gets a usufruct to that farm. What does it actually mean? A is the owner, but B has unlimited use to that farm. Let's say there's 4 kraals on that farm, and they decide, okay, A is going to use 2 kraals, B is going to use 2 kraals. B is by no way limited to using those 2 kraals. One day B decides, I want to use A's kraals as well. A can do nothing about it. What does A go and do? Build new kraals. B decides to use that as well. A says, that house you're living in, I want to use it as well. And all of a sudden, A is the owner, but can do absolutely nothing, because B has a usufruct, an unlimited right to use the property. Now, I'm not saying that's what these individuals are going to do, because that wouldn't be the right way to deal with the situation, but you never know what happens. Things could go sour, and B could go and see an attorney and figure out, hold on, I have the unlimited right to use this property. That's exactly what I'm going to do, you know? So to put it in perspective, I remember looking at transferring a farming property a couple of years ago. I think, if I recall correctly, obviously my memory is a bit hazy on it, was just before COVID, but this farming property had a municipal value of around 2.5 million rand, right? 2.5 million rand. So those who know a bit about property will know that often municipal valuations are less than what the actual valuation of the property is. But let's stick with this 2.5 million rand. Now, the thing about this farming property is that it had a usufruct over it. So someone else had the right to use this property. Now, they were going to sell this farming property. They obtained consent from the usufruct holder, but the transfer was the property is being sold subject to the usufruct holder. All right. So if you were going to buy this property, you're going to buy it knowing someone has an unlimited right to use this property. Now, what I'm trying to say was that property was valued at 2.5 million. They then did a valuation on that property with the usufruct holder to see what it is now worth, seeing that there is a usufruct holder. That value went from 2.5 million to 450,000 rand. In other words, a 2.5 million rand farm dropped down in value to 450,000 rand. So it lost around about 4/5 of its value just because it had a usufruct holder over it. Okay. So what's these ends of my story is usufructs have big impacts. And yeah, theoretically, we need to understand it's the right to use something, but practically we need to be better as attorneys. We need to be able to know that that right is not qualified. In other words, it can turn into a real train smash for our clients going forward. So be careful when we look at usufructs. You know, in reality, I would only give usufructs to, how can I put it, to people that that don't necessarily want to use the property or don't have a need for that property until a very much later stage. But when people are sharing in a property, the usufruct holder can be quite dangerous. All right, I hope that opened our eyes up to that aspect, which strongly falls under testate law as well. Just another aspect of testate law, and I just want to make sure we're all on the same page. I'm sure we've heard of the term fideikommism. Now, just to spell it, for those who are just making notes as they're listening to me, it's FEDEICOMMISSUM, a fideikommism. Sure, we've heard of a fiduciary before. I'm sure from in varsity, I think we all had testate law, so these terms should come to mind. A fideikommism, this is when property is transferred from one person to another. In other words, in my will, I say when I die, my house must go to X, but when X dies, the house must go to Y. So I'm leaving the property to go over more than one generation. The point I want to just make over there is twofold. Number one, if you do leave a fideikommism in your will, just remember, by law, it cannot go over more than 2 generations. So if I leave it to X and say when X dies, it must go to Y, that's where it stops. If you want a fideikommism to keep going, Y must then create a new one. But you personally can only go it over 2 generations. Secondly, X in my scenario was the first one to get the house. Just know and understand that X never ever became the owner of that house. X only became the rightful holder of that house, because my will said when X dies, it must go to Y. So when X dies and Y became the owner, Y then became the rightful registered title deed owner of that property. So the first person in a fideikommism never becomes the owner, because they just hold the property until the next one inherits. But let's say while X is busy holding the property, Y passes away before X passes away. You would agree that now the fideikommism becomes impossible because there's no longer any Y. So in such a scenario, by default, X would become the owner because of impossibility of performance. Right? Ladies and gents, what I'm thinking is let's take a couple questions at this stage. If you have a question, please mention your name. I'll hear your name, call your name, and I'll take your question. You can proceed.
Gimakatso.
Makatso, I'm listening.
Okay, I just saw with regards to section 2C of disqualified descendants, I just want to get some clarity. If a descendant is disqualified, can their descendants also inherit from your from your inheritance, if I can put, if my child kills me, can their child inherit from my will?
100% Imakatsu. So
Genesis.
if your child kills you, then your child will be disqualified. But the rule says if they're disqualified, then their descendants can take their place. So your child's children will then obtain the inheritance. Is that what you were asking?
Yes, that's what I was asking, because somebody in the chat group just mentioned that there was a miscommunication with regards to that section, that a descendant who is disqualified, their descendants cannot inherit from your inheritance. So I just wanted clarity on that.
No, it isn't indeed that way. I actually had a hard time with that one for a long period of time because it didn't make sense to me in such a scenario. But the rule is that what they've tried to enforce is people shouldn't be punished for other people's actions. You know, someone asked me a while ago, but what, you know, they could kill you and then their children could get the inheritance and they could make some other deal with their children. But remember, if they've killed you, they're in jail. So it wouldn't be much of a deal to be made over there.
Noted. Thank you.
Perfect.
Genesis, right?
Arisen.
All right. Hi, Carl. I just want to go back again on the 2C. You mentioned the testator can amend section 2C. Can you kindly explain again on that part?
Okay. So what I mean by that is, okay, so the rule says if you repudiate or if you predeceased or whatever the case is, this and this happens. But you can in your will indicate that I leave my inheritance to X. But if for whatever reason X can't inherit, then it must go to Y. You know, and for whatever reason if Y can't inherit, then it must go to A. So you can in your will indicate who can take the place of other people should they not inherit. If you do not indicate who substitutes them, then 2C will come into effect.
All right. Thank you.
Perfect.
Harrison.
Romeo.
Okay, there's
I
two
wanted
people who
to
went at
ask-
the same time, the lady and a guy. We'll have the lady first, and then gentlemen, you can go directly after her. Go for it.
No problem.
Thanks.
Mr. Caseman, I wanted to ask with regards to the adopted child, when it comes to customary adoption, what then happens to customary adoptions where a child is taken from a family, but there is no formal writing or formal paper saying that this child has been adopted? Then later on, the parents pass away. Do they get to inherit?
You see, that's a very interesting aspect of the law, you know, because customary law runs quite differently to South African law. Now, you know, when you adopt, you formally adopt and there's papers to prove it. But in customary law, a lot of things are obviously dealt with a bit differently. So what happens is when there is argument as to whether someone was adopted, because remember, obviously in customary law, there's not necessarily papers to say I've adopted this individual. Someone might just be living their whole life by their uncle or aunt, and that becomes sort of their new parents. But if that is questioned, you know, and if it's questioned whether you have been formally adopted or not, it is often left to argument in the court. And it can become a bit of a headache because, you know, as mentioned before, only the High Court is jurisdiction. So these things are not cheap, you know. So if there was a dispute whether someone was adopted, then in terms of customary law, you would be allowed to argue it in the courts just to prove that there was an adoption. But, you know, if you're following South African law, then there should be papers. So there's a bit more leniency in the customary law aspect. Did I cover you there?
Yes, you did, so thank you.
Perfect. That gentleman, your turn?
Harrison.
Yes.
Okay, Kyle. I just want to find out in terms of drafting wills. I know that the will must be in writing in terms of the provisions of the Wills Act, but if the will is not in writing, like in a paper, say on an email or something like that, but clearly the testator has the intention of expressing their final wishes on that email, but it's not on the it's not on the paper. Like it's not in the paper. There's no witnesses. It's just electronic email, and yeah, I just want to find out if that will be covered by section 2.3.
Harrison, it's a very difficult aspect of the law, and we're advised to strongly stay away from that. The reason being, if you go and you look in the case law, very rarely has such documents been regarded as a will. Now and then people have been able to successfully argue it, but in most instances, the decision by the courts is it hasn't required all the formalities, so we cannot count it as a will as such. So I'm very skeptical to say, even this whole electronic wills thing, it doesn't cover you 100%. If you go have a look at the case law, there's been too many issues where it's this time they accept it, next time they don't accept it. So, I would, from a basic point of view, I would say, no, it's not advisable. Your will not count, barring there may be exceptions where the courts do regard it as being good enough. But I'm a bit skeptical to walk down that road.
Thank you, sir.
All right.
Ismail,
listening.
When you someone has signed or has put in a mark, you have indicated that there must be a commissioner of oath. But I wanted to ask, who is deemed as a commissioner of oath in that contest?
So anyone who's a commissioner of oaths that doesn't have a direct interest in the matter. So, as a lawyer, you would be a commissioner of oaths, but you can't commission something that you have drafted or have an interest in. So if you needed something like that, I would obtain, another attorney to come along and to commission that document. Or anyone who, a lot of people can just apply to become a commissioner of oaths as well. And a lot of accountants are commissioner of oaths as well. So whoever is formally regarded as a commissioner of oaths in terms of the law can do so. And as an attorney, you would also be.
Gideon.
I'm listening.
With regards to repudiation and the surviving spouse, when I repudiate, when do my children inherit, or when does it go to a surviving spouse? Can you explain that?
So let me give you a practical example. Let's say you are married. You have a wife and 2 kids, for argument's sake, and you leave your entire estate to your wife and 2 kids. Now, let's say your wife and kid A and kid B. Now, let's say, if we can just mute, I'm just hearing myself in the background. Thanks. Ladies and gents, if we could just mute even the ones I'm speaking to, because I'm getting myself. Okay, so let's say, okay, you have your child A and child B and your wife. Now you've left everything to all 3 of them. Now child A decides, listen, I do not want the inheritance. I repudiate. Okay, I don't want it. What will happen with child A's inheritance? It'll go to your wife. So when you repudiate, your surviving spouse will be the one entitled to the inheritance, not that child's spouse, the deceased person's surviving spouse. The only time it will go to your child's children is if that person predeceased. So let's say A died and you never changed your will. Then let's say A had children. Then A's children can step into A's place because A was predeceased. But the moment someone repudiates and says, I don't want it, it goes to the deceased surviving spouse. Did I answer you there?
Yes, you have. Thank you.
Ismail?
Ishmael, it's the second time I hear your name, so go for it.
Good evening, Mr. Catesman. My apologies if I didn't get down the case name, but earlier on in your lecture, you mentioned a scenario where the daughter had drafted the deceased will, and she was thereafter, it was then thereafter contested in court. And the court had, I think, ruled that as long as she can prove that she had not unduly influenced and or committed fraud when drafting the will, then it would be going in, it would go into the intestate section of the Wills Act or Intestate Act. Do you have the case name or the precedent for that? Or was that just
Ismail, that was a matter one of my colleagues did. So the exact name I can't remember, but you know what? There is precedence on it. I could get it for you. I'll get you the initial precedents that made way for that.
Thank you very
Just
much.
give me a bit of time. I'll find it and give it to you. Okay.
Romeo?
All right. I heard a gentleman, then I heard a lady.
Yes, Kyle.
Yes.
Romeo, yeah. Kyle,
Yes,
I just want to
absolutely.
find out with regards to fiduci, or what's the how to pronounce it? Fiduciation, commission,
Yes, yes.
where you leave a property. Like you say, when you leave one property, and then you leave it to the one person, and you say, look, obviously on the passing of that person, it needs to go to the next person. My question is, in this case, when the next, because you talked about 2 generations, it can only be done for 2 generations. My question is, when and you did mention, if the second person passed on, by default, the first person will then become the owner of that property. What I want to know is, if the second person that I met, that I've basically allocated the house to, if he or she has children, will they not be entitled to that?
No, so unfortunately, fideicommism is an exception to the rule of 2C. So, you know, we learned if you pass away, then, you know, you've predeceased, meaning the next one comes in line, you know. But remember, this one is a bit different because the person who created the will has already passed away. So let's say in my scenario, I said the house goes to X and then to Y. So the predeceased rule means Y dies first and X has a will. And the will says it goes to X and then Y. X never amends it. Then you can have people to step into the shoes. But in the scenario where X dies, with the deceased dies, and we still have X and Y, and then Y then passes away, then you can't have the predeceased rule step in. Then it just becomes impossible because that person is no longer predeceased because they still outlived the initial testator. So that is why their children can't step into their shoes. Does that make sense what I'm saying?
Thanks, Kyle.
Perfect.
Hi, Kyle.
Yes, ladies and gents, we'll take 3 more questions. I'll listen to you now, sir, just to explain. We'll take 3 more questions. Then I'm going to continue with the lecture, and then we'll take questions again. Ladies and gents, please don't be disgruntled if we don't hear your question, because you will have many opportunities over the course of this whole week to be asking questions. And if I missed your question about this aspect, please don't be afraid to ask it later on in any other lecture. All right. You can continue with your question, sir.
My name is Kulegani Mlambo. I want to find out something. Is there a person who's a beneficiary? Can that person be an executor at the same time?
So you see, now if you say you're the executor, that's not a problem. Now let me ask you this: did you draft the will or not?
No, I'm a beneficiary. I didn't draft the will.
No problem whatsoever.
Your name?
Yeah, I'm listening.
Hello, can I praat?
Yes, go for it.
Yes, I just want to ask a question regarding to the Commissioner of Oath. Does he initial each page? And it states in the book that, excuse me, I'm very sick at this moment.
No problem.
It states that he will certify as soon as possible. What does it mean as soon as possible?
Okay, yeah, no, just to recap on your question there, I just lost you for a second there. You say the Commission of Oaths, do they need to certify each and every page? Was that your initial question?
Yes.
Yes, most definitely. So a Commission of Oaths will need to, when you commission a document, the rule doesn't change. To legally commission a document needs to actually certify each and every single page as such. So that will definitely need to take place. And, you know, that could just mean by the commissioner's signatures on each and every aspect of the will, next to the testator's signatures or marks or whatever the case may be. That's good enough. And the certifying thereof, that has got nothing specifically actually to do with commissioning a will because someone has not made a mark. What that's got to do with is when you go and give the will in at the master's office when someone passes away, it's important that if a client left a will with you, that you actually certify that as true and correct when you give it to the master's office. So that is what they're referring to over there.
Thank you.
Perfect.
Hello.
Hi, Kyle.
Okay, there was someone who clearly came through first over there. I don't know.
Yes, that was me.
Okay,
Viewing.
go for it. Go for it.
I'm just going back to the section 2C. So we talked about where the person repudiates the inheritance. What happens when there's no surviving spouse and there's no other child, or so there's one child and one spouse, but there's no surviving spouse? Do they go then to interstate rules?
Okay, so it could happen either way. It could happen that if you repudiate, then the deceased didn't have a surviving spouse, or it could happen if you're predeceased, you don't have any children to take your spot. So what the rule then says is if that can't happen, then the money falls back into the deceased estate and will be shared equally amongst the other heirs. Does that assist you?
I'm just thinking of a scenario where it's my will, my spouse is obviously has passed. I don't, the one child says, no, I don't want the money. So it goes back to my estate and then goes the interstate way.
Okay, so there's no one else in your will that you've appointed as an heir, am I correct?
Yes.
Okay, so then your will, then it's impossible to fulfill your will. Then it means you actually haven't died testate anymore. Then you've died intestate. Then it'll go according to intestate rules.
All right, thanks.
Okay. But if you had another heir, if you had another heir, then that heir would have then got the inheritance as such.
Okay, thanks.
Perfect. Hi. Okay, the lady who said hi to me. You're the last question, then we're moving on. Ladies and gents, for those who I didn't get a gap to ask to answer questions, please, as I've mentioned earlier, you'll have plenty of opportunity to still ask me the questions. Just keeping track of them. So let's take this as the last question. I'm listening.
Thank you very much. I just wanted to ask, is there any scenario that you actually having the deceased estate falling to the authorities, for instance?
There is potentially a scenario like that, which I will still come to. You know, but that would literally mean that, let's say you died with a will. You know, I don't see that actually happening if you died with a will, unless there's literally no one to inherit and you die intestate and you have literally no family members anywhere, then that could happen. But I will still explain to you, you know, a bit more in depth when that situation may present itself. I think we'll get to it either tomorrow or latest Wednesday.
Thank you very much.
Perfect. All right, ladies and gents, let's continue a bit more, and we'll take a couple more questions now again. Okay. So back to our discussion about testate law. Another thing I think worth mentioning, ladies and gents, is I'm sure we've heard of the term that we also can get a joint will. So a joint will is when two or more persons create a will in one document. So I'll just repeat that. A joint will is when two or more persons create a will in one document. Now, ladies and gents, you typically, I mean, to try and make this as practical as possible, you would typically find that in you know, with spouses, with married couples, you know, you'd often see them create a will that will say, let's say, if husband dies, then wife must get this and children must get that. If wife dies, then husband must get this and children must get that. If wife and husband die simultaneously, then children must get this. If wife, husband, and children die all simultaneously, like, for example, motor vehicle collision, then these people must inherit. So a joint will is a nice way of running your estate, you know, especially if you are married, because often, you know, the way you look at things at that stage is it's you and your spouse and your kids, or whatever the case may be. And you can put all your assets under one will, if you would like. And that is an option that's available. So you don't necessarily have to have a will on your own. You can have it with another individual as well. As long as we know that, then we're okay with that concept, And I think, typically speaking, and maybe again, just to venture out on what I've come across in practice, and I'll speak, about married couples with children now. And obviously, not everyone is in that position. But, during the course of someone's life, they may have had kids or may have been in a relationship, and you can't always plan your will that one day when I die, this is what's going to happen, because you could die tomorrow. And you've got to sometimes think, what happens if I die tomorrow? The way I've structured my will might be good for if I die later on in life. But if I die tomorrow, it might not be that great. What I have found is, if you are in a married relationship or, in a partnership or together with someone, it can be girlfriend and boyfriend, but you're living together and you have children, it's very important that you protect your partner, right? People are a bit too quick to leave things to the kids. What I've picked up on that, the biggest issue we find is, if your spouse is okay, then your children are okay. But if you pass away tomorrow and your kids are 5 and 6 years of age, if your spouse is not okay, the children are not okay, because they are the only one left to look after those kids at the end of the day. So I'm just trying to open our minds up to estate planning here. I don't think it's clever thing to create a will and this is the way it's going to be forever. I think your will constantly needs to be adjusted. Whilst you have minor children in the house, make sure your spouse is okay, that if you pass away, they are able to look after those kids. Keeping in mind, with you gone, they have lost an income. And especially if you were the breadwinner, how are they going to raise those kids? It becomes a real difficulty in life. And the only reason why we face those difficulties is that individual who passed away just thought it's the right thing to do to leave my inheritance to my children and my spouse collectively, for example. Not thinking that, your children can obviously only inherit when they're 18. What's going to happen until they're 18? How is that spouse going to have the income to look after those kids until they reach the age of 18, And perhaps at a later stage in your life, your children are majors and your spouse doesn't need your income, or you've got a policy to cover that scenario. Then your will can change and you can adapt it. But I think when we talk about testate law and a will, I think we talk heavily about estate planning going forward. What's important if I die today? Because when you create a will, that's what you've got to explain to your client. We've got to create this will as if you die today, right? What's going to be the best? Not what you think in 10, 20 years from now, because then we change your will, as time goes along. I think that's an important aspect just to keep at the back of our minds, Like I mentioned earlier, when dealing with people's wills, it's not just common law, but thinking about the practical scenarios in life that can play its way out. Because, like I said, it's important we look after those that we leave behind. And there's a lot of people that's often dependent on our salaries and our incomes, even though we might not even be the breadwinner as such. But anyways, that's something that you would need to discuss with your client. What I want to talk to you about is just a couple aspects of, in a will itself that we need to be conscious of, Now, I mentioned earlier that we have freedom of testation. So I can't tell you how to draft a will. I can't mark you wrong on your will, because a will, as long as it requires the formalities, is completely correct. I mean, we've covered this. But I did tell you there's a difference between a good will and a bad will. So what I think is we need to try and think about or understand the different clauses that we can find in a will. Once we understand what possible clauses to look out for when drafting a will, what we say under that is completely the instruction of your client. So I cannot tell you how to draft a will, but I can tell you what to consider when drafting a will. I mean, your client is just going to come to you for one purpose, and that's 10 to 1 going to be, when I die, this is what I want to happen. That is what most people come to draft a will about. I want to leave my estate to this person or that person. But there's so many other elements to a will we need to consider. Now, let's go over a couple different clauses that we should find in a will or understand. So, number one, the very first clause that's part of a will that I think we need to always put in is one thing that we've already discussed. And I mentioned to you the revocation clause. You know, it's very important to start your will with a revocation clause just to revoke all previous wills. Because you do not want a scenario when someone dies with more than one valid will, because it creates confusion and often ends up in the High Court and sucks money from the deceased estate because of that will. So that's something we want to stay away from. Now, the second thing I want to make mention of is what we call collation. C-O-L-L-A-T-I-O-N, collation. Now, I think it's important we make our notes about this because this is common law as well. So collation is something that applies in common law, and it's something that applies to all of us, ladies and gentlemen. We cannot escape it, meaning that if we do not talk about it, it is automatically there. That is common law. If we don't want it, we need to specifically say in our will that we don't want it, right? Just like section 2B, 2C, and all these aspects of common law we are talking about. So what is collation? Collation is, again, another assumption in our common law that applies to your direct descendants. So this only applies to when you die and you have children and you're leaving things to your children. So let me give you a practical scenario. So there's a common law assumption that you would have wanted your children to benefit equally. I'll say that again. There's a common law assumption that you would have wanted your children to benefit equally, unless, of course, you state otherwise in your will. Okay. Now, that is not just through your inheritance, but that is through the course of your lifetime as well. Let me give you a scenario. Practically speaking, all right, let us say you tell your children, you have two children, you tell your children, when you are 18, I'm going to buy you a car. All right, you die. When you die, you had one child that was 18 and your second child that was 16 years of age. Just before you passed away, you bought your 18-year-old a car. Let's say 100,000 Rand car. Okay, now you pass away and you say in your will that your two children are your heirs. They must get your entire estate. According to collation, the common law assumption, we cannot split your estate equally between your two children because your 18-year-old has benefited more than your 16-year-old because your 18-year-old got a car and you didn't get a chance to buy a car for your 16-year-old. So if that car was valued at 100,000 Rand, we first need to go and give your 16-year-old child 100,000 Rand. Because once we've done that, we have now put your two children on the same footing. Now we can take your estate and divide it 50-50 between the two kids. So again, this is an assumption. Now you might listen to it and say, well, that sounds very fair. And I would agree with you. However, there is practical implications, what I've noted in real life. Now, what you often find with collation is if you say, well, this kid got more than that kid, so we've got to first give that kid this before we split the estate. What often happens is they start arguing. No, but you got this, but you got that. We had a scenario like that a couple of years ago where there was a couple of children involved, and it turned into a huge argument over who got what during their lifetime. And we couldn't reach agreement. We couldn't reach finality over who must first be put on equal footing before we can divide the estate. And it delayed the devolving of that estate by a very long time. Now, I can put it to you this way. Every client I've had, and I've explained to them collation. Once I've explained to them the positive and negatives of collation. Positive is your children will be put on the same footing. Negative is there's a chance they fight about who got what. I can tell you now that most clients have told me they don't want collation. They don't want people to fight about, their children to fight about their deceased estate, because that's not the way they want to be remembered. They don't want any fighting. So they say it might be safer to just not let collation apply. Because if you got something, lucky you, but I don't want people fighting over my deceased estate. So you've got to look at it and explain it to your client. Again, just like 2B, 2C, and everything else we've been speaking about, you've got to tell your client, listen, another assumption that applies in our law is collation. This and this is what collation is, applies to your children, they put on equal footing. This is the positive, this is the negative. If your client says, no, collation sounds good to me, you don't need to speak about it in your will. Why? Because it's common law, it automatically applies. But if your client does not like collation, then make sure that one of the headings or clauses in your will is collation. And it says collation will not apply, right? But again, it is wrong to just not mention anything about collation to your client, ladies and gents. You've got to give them the chance to decide if they want it or not. Just like you've got to tell them about 2B and 2C and everything else. Because if they don't want it, you need to amend it in your specific will. So the second clause that comes to mind that your client might want is the collation clause. I hope I've brought clarity to that common law assumption. And please, have a look at it. It's an important aspect of our law. Right. What other clauses come to mind? The executor clause. The executor. There needs to be an executor, and this is obviously the person in charge of winding up the deceased estate. Now, ladies and gents, I'm sure you know there are various attorneys and banking institutions that obviously do not charge for drawing up a will for their clients. And the reason being is they're not interested in charging for drawing up the will because they're going to make their money when that person passes away. That's the reality behind it. As executor, you are entitled to 3.5%, so 3.5% of the total assets of a deceased person. Right? I'll say that again. As an executor, your fee for winding up the deceased estate is 3.5% of the total value of the assets of that deceased individual. Now you can think if you deal with a person who has an asset value of 10 million, I mean, 3.5% is 350,000 Rand that you make for winding up the deceased estate. So there is potentially a lot of money in it, and it's definitely worth being executor of wills. A lot of practices form the basis of their foundation of income from winding up deceased estates. Obviously, your duties as executor we'll still talk about later on in the week. That involves winding up the deceased estate. That is our third and final aspect that we'll chat about later in the week. But for now, you need to know that if you are drafting a will, you're 10-to-1 drafting a will because you want to be the executor of that specific will. I don't think you would do a free will for someone if you're not the executor of that will, I would assume, right? So you need to appoint someone to wind up that deceased estate the moment you pass away. And if a client is coming to you, there's obviously a great chance because they want you to do that duty. When you have an estate of value, it is not recommendable to let a family member wind it up because they would simply not know how to do it, especially when it comes to drafting the liquidation and distribution account. That is a skill that you need to have. Right. Another interesting aspect about being an executor as such is sometimes the master's office might require you to give security before you start winding up a deceased estate, right? Now, security is sort of like, it could be in the form of a bank guarantee or deposit of funds that you need to put down before you start winding up a deceased estate. Now, let me just explain that to you. Some deceased estates that you are the executor of might be quite complex. I mean, you can think for yourself that some people might die whilst running businesses, etc., etc. And you then, as executor, would have to take over on behalf of that deceased person and close down that deceased estate in the most profitable manner for the beneficiaries. Now, the problem is the master's office might say, right, you're the executor, but we're a bit scared you're going to be negligent in doing this process. It's complex to close down this deceased estate. There's a lot of things happening at the moment in this estate. So they might ask you to give security. In other words, put down a bank guarantee of X amount that if you are negligent and you cause damage to that deceased estate, we're taking it out of your own pocket. which is obviously not a great concept for us to think about. So what happens in such a scenario? What I like to do is I explain that to the client, and I say, well, the master might ask me to give security. Do you want me to give security, or would you be fine with me not giving security to the master's office? And if the client says, look, you don't need to give security to the master's office, I trust you, just wind up the deceased estate, then I add a clause to that will, and I call it a security clause. And I just say there, the executor need not furnish any security to the master's office. Now, I can ask each one of you, do you want to give security to the master's office? And I'm sure all of you will say no. No one wants to give a bank guarantee of any money or put money down before they start doing a job. But the master's office may require it. So I try to eliminate that scenario by putting a security clause and saying I will not have to give security. I will just qualify what I'm saying over there. Sometimes, even if you have a clause that says you don't need to give security, the master's office can still compel you to give security if it's a very intricate and delicate and complex estate. So it does not necessarily 100%
Hi, Kyle,
guarantee.
your line is breaking.
Can you hear me better now?
Yes, we do hear you. I think maybe she might have a problem.
Okay, all right. So let's just continue then. So it does not necessarily exclude you from having to give security, but it does bring your chances down from having to give security, because the master's office would look at it and say, well, the deceased person didn't want the executor to give security, so we're not going to ask that person to give security. But it is worth adding that clause because it makes the chances less likely that they ask you to give security. So that's more of a tip that I'm giving to you. So again, ladies and gentlemen, we've looked at a couple clauses, namely revocation, collation, executorship, security. These are clauses we have to think about and include in our will. And I can promise you, your client hasn't come to speak to you about any of those clauses. So there's a lot more you have to talk to your client about. I mean, another clause that comes to mind that might be useful is what they call a professional fee clause. A professional fee clause. Sometimes when you wind up a deceased estate, you might feel that you need to get a certain expert in to assist you. Because some estates, like I mentioned, there could be things happening in there that you are just not qualified to deal with, or you're just not too sure how to deal with certain things. And you might feel that you need to get a third party in to come in and assist you in closing down this deceased estate in the most profitable way for the beneficiaries. So by adding a professional fee clause to the will, you are telling, you are saying that should you require an expert for assistance, you can call an expert in and the deceased estate will pay for this expert, in other words. So it is a safety net we use in case we need to get a professional in. So that's another clause that we could look at, because obviously, ladies and gents, you can't just hire people to assist you and then think you can take money from the deceased estate to pay them. No, you can't do that. You need a professional fee clause that gives you permission to do so. Okay, so there's a couple clauses just to think about. Now, that goes without me even saying you got to think about 2B and 2C and all those other little aspects there too. But why has the client come to see you? Probably to say who is getting what. So in other words, we've got to distinguish between legatees and between heirs. So we've got to distinguish ourselves between legatees and heirs. A legatee is someone who gets something specific. Say that again. A legatee is someone who gets something specific. If I give you my house or my car or my CDs or 100,000 Rand or 10 Rand, it doesn't matter. I've given you something specific. You are a legatee. An heir is someone who shares in the residue of our estate. So an heir is someone who shares in the residue of our estate. In other words, they share in what's left of the deceased estate. Now, I mean, you would typically find, let's take the scenario of spouse and 2 kids. You might say, when I die, my spouse must take my house, for argument's sake, and my kids must get the rest. So your spouse would be a legatee and your kids would be the heirs. But you can also be a legatee and an heir. You can be both. It doesn't matter. But just keep in mind, when you're clearly identified, you are a legatee, and heir is someone who gets the rest of your deceased estate. You know, and also I think it's important for me to add that a legatee is ranked above an heir. So I mean, if a legatee must get something specifically, they must get it. An heir only takes what's left. So an heir is last in line. Whatever is left in your deceased estate is what they get. I mean, if I wanted to be 100% honest with you right now, we can actually put our ranking in 4 categories. You have creditors, marriage, legatees, and heirs. When you die, everyone you owe money must be paid. They're your creditors. Next in line is your marriage regime. The way you are married definitely determines what's next in line. They take whatever their cut is. Then come the legatees, then come the heirs. So the heirs, you know, often people think is these the people who's going to inherit because they're getting everything. But just keep in mind, they get everything only of what is left at the end of the day, right? But in essence, your client has 10 to 1 come to you to discuss legatees and heirs, who they are going to leave things behind to. I mean, another aspect, perhaps, you know, that obviously could be of importance, especially in a joint will, would be guardianship. You know, if they were to die, who is to look after their children? I mean, it goes without saying that if mom dies, dad looks after the child. If dad dies, mom looks after the child, whatever the case may be. But you know, in reality, you know, sometimes one of the parents might have passed away already. Or what happens if the parents pass away simultaneously? Or what happens when one of the parents aren't fit to look after the child? You know, then guardianship is quite an important clause that comes into account, and something that we'll need to think about, especially obviously only when we have minor children. So that's also potentially something your client might have wanted to chat to you about. And, you know, the interesting clause that also comes to mind for me is you know, funeral direction or bodily remains. You know, a lot of people are quite interested in that. You know, in other words, when they die, should they be buried? Should they be cremated? You know, where should the ashes be scattered? I mean, what is your personal preference? What I can tell you is, ladies and gentlemen, I don't think it's a clever idea to, in your will, indicate if you want to be buried or cremated and to just be silent about it. Because by the time people have looked at your will, you've already been buried or cremated. So if you want to be buried or cremated, or whatever preference you have, make sure, if it's in your will, make sure you tell your close family members about it, because it could be quite an impractical thing if you've kept silent about it. And your body remains as well. That's also something you should be telling other people about, not just in your will. If you are interested in donating any of your bodily organs, you know, for research when you pass away, because a lot of people are, then I think it's important that I tell you that in your will, you have to be specific about who is to receive your bodily organs. If you just indicate that your bodily organ should be donated for whatever research purposes, that is an invalid clause. It is only valid if you indicated specifically which institution should receive your bodily organs. Okay. Now, there is another clause about a will that I want to discuss, but I'm kind of holding back on it. I think at this stage, let's open the floor up to some questions again.
Leonardo?
What's I'm listening?
I've heard before that a power of assumption clause is very important for an executor to basically appoint someone to assist them, perhaps with accounting or legal knowledge. Is that implied in your executor clause that you mentioned or not?
That was applied in my professional fee clause, as I mentioned. And you're quite right. You know, a power of assumption, the power to, in other words, when you say a power of assumption, the power to decide whatever is necessary in order to wind up this deceased estate in the best way. And, you know, that goes hand in hand with the professional fee clause. Some people call it a power of assumption clause, you know, which just gives you the power to say, right, I'm appointing you and you to assist me in doing this and that, and the deceased estate is paying for it. So you're 100% right. That is an important clause. Some people call it professional fee. Some people call it power of assumption. Some people use both the names of those clauses in the same will, but they kind of have a similar effect.
Okay, thank you very much. What did you mean with your executive clause? I didn't make sufficient notes on that. Can you maybe just repeat quickly? Thank you.
Perfect. So the executive clause is when you appoint someone to act as executor of the deceased estate. So if someone's coming to you to draft a particular will, then you're going to have an executive clause. You're going to say, well, I appoint Carl Kitzman, ID number so-so, to be the executor of my deceased estate. So in other words, when that person passes away, I am the one in charge of winding up that deceased estate and closing it down for the beneficiaries. So that would be the purpose. You need to have someone doing that. So you'll need to appoint an executor to wind up the deceased estate when you pass away. And the steps involved in winding up the deceased estate we'll cover a bit later in the week.
Perfect. Thank you so much.
Hello, Carl.
Hi, Kyle.
Hello.
Yes, go for it.
I've been waiting a long time.
Go for it. I'm listening.
Okay, I made a comment earlier regarding the Islamic law of succession. I made a comment that our law, especially with our module called Aspects of Customary Law, it highlights African customary law and Islamic law, but it doesn't recognize Mosaic law. Since we are in a democracy, we should actually recognize Mosaic law along with Indian law, because we also have Indians in our country.
Yes.
And also, I found out the difference between a republic and a democracy. We are the Republic of South Africa, meaning a republic takes into consideration the majority and the minority. Democracies only take into consideration the majority. So we should fight for this country to be a republic.
I hear you, sir, but that is, look, I agree with your principle on that, you know, because it doesn't matter if you're the majority or the minority, you know, you should be sought after and looked after in terms of the law. But, you know, that's a bit out of my control, you know, and that's something for the legislators to deal with.
Can I
Carl.
go in? Harrison? Okay,
Harrison, I
Can
heard
I
you and
quickly
then I
ask
heard a
something?
lady. So,
yeah.
so Harrison, go
Yeah,
ahead.
I just want to ask something about security. It's just a short question. Okay, you say sometimes you need to put up a security for you to wind up somebody's estate. What if they choose me and it's a huge estate and I do not, and the master forces me to actually put a security and I'm the family member? What happens if I don't have funds for the security? Will they cancel me as an executor?
Yes, they would. If the master's office demands security to wind up a deceased estate and they don't accept your explanation as to why security should not be given, then they won't appoint you and they'll need to appoint another person then, unfortunately.
Okay, all right, cool.
Perfect.
Hi, Carl.
Harrison, I know you were also on the line.
Yes, I'm here. Should I still let the ladies go first?
You can go, Harrison. Then I think there was I heard another lady say, "Ah, Carl, she can go straight after you."
Okay, let me go for it. I've got two questions. One question is with regard to the executor. I'm not grasping the term correctly because I'm not so sure if the executor will be a professional or an attorney. That's number one. Then number two will be the witnesses on the will. Do they have to read the will or they just need to sign without knowing what is happening in the will? Thanks.
Okay, perfect. So Harrison, on the second one, the witnesses don't need to read the will. They must just sign in the presence of the testator, and the testator must sign in their presence. So they are just there to witness that this will was indeed signed by the actual testator of the will. That is their sole purpose over there. And then the other one is, I think you mentioned, you know, does the executor, can it be any person or should it be an attorney? You know, you see the thing is, Harrison, by law, it can be any person, most definitely. But it is not a practical move to have a larger estate and to have a family member be the executor, you know, because you'll need to draft the L&D account, a liquidation distribution account. And I don't see a family member being capable of doing that if they're not qualified or don't have practical experience there too. But I think there's a big difference between letters of executorships and letters of authorities. You'd often see family members walk around with letters of authorities, and the banks and attorneys with letters of executorships. And there's a big difference between the two. But I don't want to get into that just yet because that's for a bit later in the week. But yeah, if I would just in short say, if you have assets of more than 250,000 Rand, my advice is get an attorney or a bank. If your assets are less than 250,000 Rand, you can get a family member because they would be able to wind up that deceased estate. But I'll get more into it later on. I hope I covered you there. All right, we had.
Thank you, Carl.
Perfect. We had the lady.
Hi, Carl. It's Tanya. I just want to get back to one of the earlier questions and topics with being a disqualified beneficiary. I can't remember where in the textbook, but I did see something about if you can be deemed unworthy to benefit, and then your descendants don't inherit your part. Is that true? And then if it is, what would make you an unworthy beneficiary?
You see, the general rule is your descendants step into your shoes, you know, if you're disqualified. But I know there has been instances in the past where they've also been disqualified, but it doesn't form part of the exact rules. You know, and it's often found out when it can be sort of shown that you had a specific motive with that person's inheritance. So when they speak of this unworthiness, if you killed the testator, but there was a motive behind that reasoning, you know, that would influence your descendants as such, they can actually bar you or bar your descendants from stepping into your shoes. But that's not the exact law. That's an exception to the rule. And it has happened in the past where descendants have been barred. But they speak strongly about the motive behind sort of your killing. If it was, you know, for the benefit of your children, you know, and in other instances where your children were aware of it, etc., then they can be barred as well. But it doesn't always happen in that way. But, you know, it's also one of those aspects in law where, you know, if you go read up on it, you'll find out different situations fit different situations in different manners. You know, it's difficult for me to explain it. All I can tell you is that can happen, although it's not in general the hard and fast law.
Okay, all right. Thank you very much.
Hi, Kyle.
Hi.
I just have a question about the professional fee clause. So what happens if it comes, I don't know, maybe someone finds out that there was actually no need to appoint such a professional, and then because maybe it was unethical to actually do that, would then will that clause fall away, and would that deem the whole will invalid just because of one clause, or is it still valid despite the other clause being? Is the will still valid despite the invalidity of the other clause? I don't know if I'm making any sense.
No, you're making sense. So one clause will never deem the whole will invalid. You know, so if one clause has been dealt with in an incorrect manner, the rest of the will must still be read in its entirety. So that wouldn't cancel the will at all. And in your specific scenario, if that professional fee was not necessary, then and someone took exception thereto, then it would be negligence on the part of the executor. And the master would obviously demand in writing reasons why you've done so. And if you fail to give good reasons, they could remove you as executorship as a result. But the rest of the will still be devolved as per the content thereof.
And if can I just follow up on that? So if the fee was already paid to that professional, and then only afterwards it was found that it was unethical, would they have to pay back that money? Okay.
Well, you see, the thing is, it wouldn't be unethical on the part of the professional. It would be unethical on the part of the executor who allowed this to happen. So they could be held liable for it, most definitely.
Right. Thanks.
Perfect.
Hello, can you hear me?
Go for it.
Yes. I'm gonna ask a question about the revocation clause. I understand revocation clause is very important, but I've seen so many wills, all of them have got the revocation clause. Now my question is it really absolutely necessary to complete or to fill in the revocation clause when the customer is for the first time that he is now applying for the will?
So if it is the first time, then it would be irrelevant, because there's nothing to revoke. But why you will see people do it is they do it for in case there is another will, because, it's happened to me personally as well, where someone told me they didn't have a will, but later we found out they actually did do a will many moons ago that's sitting by a bank that they actually forgot about. So we do it automatically just as a safety net to avoid any issues. But if that is literally your first will you're ever making, then a revocation clause would serve no purpose then, eh?
Oh, yes. Thank you very much.
Yeah. Perfect.
Hi, Kyle.
Hi, Kyle.
Okay, I heard the lady, then I heard the gentleman. So let's go lady, then gentleman. Go for it.
Okay. So the name is Motlatso. The name is Motlatso, and I'd like to ask a question regarding the security. Does it have to be financial only, or can I give in, say, a car or some movable property instead?
Well, usually security would imply a bank guarantee then of X amount of money. So, look, I've never inquired with the master's office if I can give an asset as security, but I do know they require a bank guarantee of X sum of money that will be held, for in case you are negligent in the process. So, yeah, I want to say no, you can't give an asset as security because I've never seen such a thing. But I'm not 100% sure because I've never looked at it that way or never asked them, to be honest with you. So it's a bit of a non-answer from me on that one.
Noted. Thank you.
All right.
Gentlemen, just a few ones. I just wanted to find out that if in an instance where the will has met all the requirements as set by the law, except the date part, what happens if there is no date? Is that will deemed to be valid or invalid?
They actually still deem it valid, eh? They deem it valid. So it doesn't necessarily need to be dated. It's obviously a bad will if it's not dated, because it can create confusion and uncertainty, especially if there's more than one will found and there's revocation clauses involved. Because then the whole issue is now we have to figure out at what time in your life did you make this other will, and it ends up in court and it's a long issue and it drags out unnecessary money from the deceased estate. But to answer your question, it does not need to be dated, but I would always highly recommend that you do date your wills to avoid any possible issues going forward.
All right, thanks. In respect of the furnishing of security, to what extent does the legal practitioners indemnity, I think it's an insurance fund, covers the legal practitioners?
Yeah, so look, they cover you X amount per annum, depending on the size of your firm and the amount of practitioners. And they can cover you as such, but you can't use the indemnity insurance as security as such. You would have to give your own security, and if you're negligent, you could claim because it's a fund of last resort. So you could claim through them, perhaps on the basis of negligence. But what I would advise, I'll take it a step further and say, outside of the indemnity insurance fund, there is other insurance funds that you can take that don't cost an arm and a leg to cover you further in that regard.
All right, thank you. The last one now, just about the rescue provision section 2.3, which is said to be the court's overriding discretion.
Yes.
Where the court has the power to order the master to accept the document which has been drafted or executed, maybe incorrectly. Can you just a few, just want to understand that more.
Yeah, so the court is the highest authority. So look, if you look at the ranking, you have the executor in charge, but the executor reports to the master. And if there's an issue, the master has the final say. But if the issue between the executor and the master can't be sorted, and sometimes it's not between the executor and the master, it could be between the beneficiaries and the master. If they can't see eye to eye on the law or the way to deal with a specific matter, the matter can be taken to the court. And the court, as the highest authority, can make a decision on what needs to happen. And that authority overrides the master's call. So if the master wants you to do 1, 2, 3, 4, and you're not doing 1, 2, 3, 4, and you have reasons why you can't do 1, 2, 3, 4, and they don't want to accept your reasons, you can go to the court to seek an order that that overrides the master's decision.
All right, thank you.
Perfect.
Hi, Kyle.
Hi, Kyle.
Okay, I got 3 ladies that sort of went hi, Kyle, there, so it doesn't matter. I'll answer all 3.
I'm gonna ask
Go
her
for it.
quickly, this is on behalf of Caitlin. She asked on the chat box, because unfortunately background noise where she's at, so she just asked if somebody could ask if the question is if you would
Go. You want to eat? Yeah, eat. So easy.
Madam, I've lost you. I've lost you completely.
Yeah.
The last thing I heard is the question is, and then you went away.
No, go out, man.
Hi, Kyle. Please get a minute.
Yeah, go for it. I'm listening.
Hi.
The other lady, I lost her. I don't know if she had a signal issue or what happened there.
No problem. It's Unique speaking. Referring to our first session, I'm not quite sure if I understood the rule of thumb, the 3 months rule of thumb after getting a divorce order. What did you say again on it?
So let us say you are now married and there's a good chance your spouse forms part of your will. Okay. I mean, if your spouse doesn't form part of your will, or if you amend your will at any stage, then what I'm saying is irrelevant. This is only when the spouse forms part of your will and you then divorce. Okay. And then within 3 months after the day you divorce, if you pass away, the assumption is you actually don't want your spouse to inherit anymore. You haven't had enough chance to change your will since your divorce. But if you pass away after 3 months after date of divorce, then they're saying you've had 3 months to change your will to exclude your spouse if you're still your ex-spouse, then obviously. And you've had enough chance. And by the fact that 3 months has passed away since your divorce and you still haven't taken your ex-spouse out of your will, it means you still want your spouse to inherit at the end of the day. So it's basically just an assumption on only if you're married and only if your spouse forms part of your will, then you divorce. Within 3 months after date of divorce, it's automatically assumed your spouse, your ex-spouse, then is no longer, you would no longer want them to inherit. But after 3 months after date of divorce, the assumption is you've had enough chance to amend your will. So your ex-spouse will still inherit them if they were part of your will when you were married. Does that make sense?
Yes, thank you so much.
All right, great.
Hi, Kyle.
Hi, Kyle.
Yes. Back to the ladies. I think, is there anyone who was speaking to me earlier that got cut out? I want to go back to that person.
Yes, I was.
Okay.
I was speaking.
Go first, and then we'll listen to the others.
All right. So the question was just like, if you just like brush through again the massing in regards of joint wills, just for clarification of the process of massing when you're dealing with joint joint wills.
Okay, so massing I wouldn't put together with a joint will. you know, because massing is a bit separate. You know, a joint will, in essence, is two people create a will that says what happens if each of them die or both of them die, you know. Massing is when two people create a will that only benefits a third party. So what I mean by that is, if you mass an estate, the assumption is if one person dies, then they both actually die. So let's say X and Y have a massed estate, and they have a child. Let's call the child A, and A is the beneficiary of the massed estate. If X dies, then X and Y's whole estate will go to the beneficiary. Or if Y dies, X and Y's whole estate will go to the beneficiary. So a massed estate is two people who see the estate as one. If one person dies, then everything goes towards a third party. It is not something that we find a lot anymore in our law. You know, I haven't dealt with anyone who's come in and asked me for a massed estate. You know, speaking to some other people, they've said, you know, years ago, we used to find quite a lot of massed estates, you know, where two people consolidate everything into one. But these days, people prefer a joint will, because in a joint will, you're not in essence massing your estates. You're still saying, if I die, this is what happens. If you die, this is what happens. With massing, if one person dies, it's as if both people die. You know, so it's not an aspect of the law, you know, that I would advise. I would do a joint will, but I wouldn't do a massed estate, because that has quite severe consequences. You can
Thank
think
you very
that
much.
Did I answer you there?
Right. Hi, Kyle.
Yes.
Hi, I had a question with regards to guardianship, a scenario question. So let's say I conclude a valid will and I die unmarried with a minor child, and I have nominated, let's say, my sister to be guardian of that minor child if I should die. But at the time I have died, she is not financially stable to provide for that child. And an application is brought, let's say, by the father who's unmarried or the grandmother to take guardianship of the child. Will the High Court step in to alter that provision so that it is in the best interest of the child, or is the provision in the will hard and fast, and that will apply no matter what the financial situation of the guardian is?
So the provision is not hard and fast when it comes to guardianship. So that is the first, if that person was appointed, that's the first person that you know should be given guardianship. But if that person is not in a position to look after the child, then the High Court will step in, listen to oral evidence over who, you know, is financially capable of looking after the child, and importantly, who the child actually has a relationship with, and appoint such a person. So it's not always hard and fast, no.
Okay.
But I can tell you one thing, that person, you know, that was initially appointed, they could do a maintenance claim against the deceased estate if there is money there to look after those kids, you know. So it depends on the deceased estate's financial position, if they have money to give to that other person to look after the child. If not, then the High Court will have to step in.
And in the case where that appointed guardian refuses that responsibility, they will not then have claim for maintenance, I assume.
100% correct.
Okay, okay.
Remember also, if you refuse, you know, no one can keep you to it, you know, as
Okay,
well. So,
okay.
so
So
yeah,
you can't force guardianship onto someone.
You can't force anything from a will. Hey? Your guardianship,
Okay.
inheritance
Anything.
is nothing. Yeah.
Thank you so much.
Hi,
Cool.
Kyle.
Yes.
Hi, Kyle.
Yes, I'm listening.
Yes, with regards to the joint will, you said that the two testators create one, they each create their own will in one document, right? So if A dies, does B's will still remains, or does that have to change?
So if there's a joint will, was that your question? The joint will?
Yes, there's a joint will. A made a will, B made a will. A dies and the estate of A is dealt with according to A's will. What happens to B's will? Does it remain or does it have to change?
So remember, if it's a joint will, then they both have one will in one document. So they don't have separate wills. So they've put their will together in one document that accounts for what happens if A dies and accounts for what happens if B dies. So it doesn't change anyone's will, because it's only one will. It's one document between the two of them.
So when A dies, B can then revoke that will and do another one.
No, no. If you have a joint will, it counts for A and B. So if A dies, whatever the will said must happen, must happen. So let's say A dies now and B receives whatever he or she should have received from the will. Now A is no longer in existence. B can then go and create their own will of, will say, what will happen when they die at a later stage.
Oh, okay. All right. Thank you.
Cool.
Hi, Carl.
Yes, I'm listening.
I just have a question in respect of class bequests. So if we have a will and we say, for instance, I want to give X amount to my grandchildren, and a child has been conceived during this stage but is not yet born, do we suspend winding up of the estate for that period pending the birth, or do we put that amount of money or the remainder, depending on what the will says, into the guardian fund pending that birth and then dissolve it accordingly?
Yeah, so it's that old Nasitra's adage, you know, they say the child must be born alive. It's a weird term, but it makes sense. So at that stage, you know, we can't give people inheritances and then put their inheritance one side, because that person must still be born alive, you know. So it is suspended in such a scenario. The money is kept out, it's kept separate, and pending that birth, then it will be distributed thereafter. Unless, of course, someone has an interim claim as to why that money needs to be paid out in the meantime, then plans can be made accordingly. But otherwise, generally, we just suspend it to see if that child is born alive.
Okay, thank you. So that would be then an application that would be have to make to the High Court.
Yeah, you know, not always, hey, because, you know, what happens is to wind up a deceased estate is not a little story. Eh? That can take anything from 6 months to 2-3 years. I know people has been struggling for 7-8 years to wind up a deceased estate. And that's obviously, well, from my perspective, it's because the will wasn't set out in a very clear manner. And there's issues that has followed and disputes that have followed. So generally, a lot of times you actually do have time to see. What the Master's Office requires is that within 6 months from date of death, you then actually have drafted your L&D account and told them who's getting what. But let's say 6 months from date of death, and that conceived child is not yet born, you will write to the Master's Office and say, listen, you are just suspending as to who's getting what until this date because you are waiting to see if this child's born alive. And they will grant you that extra time. So you don't necessarily have to go to the High Court. You can deal with the Master on that.
Okay, thank you.
Cool.
Hi, Kyle.
Okay, I got two ladies. I got hi, Kyle, and hi. So let's go in that order.
Hi, Kyle. It's Shiwa here.
Yes.
My question is with regard to customary adopted children. Say, for example, the testator is married in community of property. She came into the marriage with the child. So when she drafted that will, she indicated that the guardians of the child that she came with into the marriage are the parents. Now, what happens when, with regard to the husband, the spouse, does he have any rights to claim guardianship of that child due to the fact that he customarily adopted the child?
You see, if he can prove he's customarily adopted the child, then that is indeed his child in the eyes of the law, you know, but one will have to prove that, because in absence of proving that, then the biological parent will obviously have rights to the child. So if you can show that, you know, that child has been customarily adopted, if you can show that to the courts, then you will have the right, because you as the adopted parent are seen in the eyes of the law as the parent of that specific child. So yeah, it comes back to that earlier discussion. When you don't have things formally on paper, it ends up into a court spat, because now you have to prove things you are trying to say, and the court will make the final decision. But yeah, if you can prove it, then you as the adopted parent have rights towards that child.
Okay, thank you very much, sir.
Cool. The other lady?
Hi, Carl. You're speaking to Kiara here. I have a bit of a hypothetical, also kind of situation, but mainly my question is, who has the right to view your will? So, for instance, in a predicament where you have your mother and your father, that let's say they have a joint will, and it's me and my sister, and my father dies, and my mom refuses to let me see the will, but I don't know if I'm a beneficiary or not. And that, let's say I've contacted the executor and he also refuses, saying that don't worry about it. It was a joint will, everything's gone to your mother, and you're not a part of it.
Yeah, you see, that happens more than a person would like to think. One easy way of dealing with it, if they deny you access, well, not an easy way. The unfortunate part is you'd have to do an application to see such a thing. As a family member, they should entitle you to see the will, because if you had the what I would do in such a scenario is, with your, let's say, your deceased father's name, surname, and ID number, you are able to go to the master's office and pull the will over there and get access to it. So you won't necessarily need their consent for anything. You actually don't. Anyone with the details can go and get access to it. Because remember, before they can wind up that deceased estate, the executor had to report that estate to the master's office, which included giving the will to the master's office. So you could go directly to the master's office and get the information over there. Should you not find it, then you would have to go the more expensive route of doing an application to see it.
Yes, okay. Thank you so much for answering my question.
All right,
Mr.
cool.
Kissman.
I'm listening, ma'am.
Yeah, I apologize. I think maybe you touched on this, but I didn't hear you properly with regards to appointment of an executor. Let's just say my husband is an attorney, and then I draft my will with another attorney. Can I then appoint my husband, who is an attorney, to be an executor?
Okay, so your husband is an attorney.
Yes. And then in my will, I draft my will with another attorney, but then I appoint my husband as the executor.
No problem. No problem whatsoever.
Okay, so then this executor, this attorney that's drafting my will won't be upset that he's losing a 3.5% to my deceased estate, right?
I'm sure he'll be upset. But,
okay.
But it's not his choice. It's your choice. I only think that if he's drafting the will, then he would probably charge you for drafting the will. As his legal duty that you've asked him or her to do. So yeah, I mean, if you draft the will for someone, I mean, if you're not the executor, it doesn't matter. I mean, you've still been appointed to do a legal job, and you'll get remunerated for it accordingly.
Thank you.
Cool.
Advocate, I just have two questions, shortly.
Go for it.
Advocate, my name is Rajendra. Just our first clause, we spoke about the revocation clause. And I was reading my notes this afternoon. I also looked at a codicil, I think where you amend certain sections of your original will. Yes. I just want to know why we are repeating, duplicating stuff, because if one has to make a revocation clause where we speak about we hereby revoke all previous wills, why still then make a codicil to amend certain other things? Unless, isn't it a duplication? Can't we just make a new one every time?
Yeah, well, you see, that's your choice, eh? So what I've come across is sometimes people want to just amend a small thing in their will. Then, you'll often find doing a codicil is the right way of going about doing it, well, not the right way, just maybe a preferential way that some people want to do. But if you're going to amend a lot of things in your will, I mean, for me, why create a codicil? Just create a whole new will then. But in essence, you have a choice. Eh? You can either do a codicil, or you can revoke and create a new will. It's up to your client. What I do in practice, if it's a small amendment to the will, then I do a codicil. But if there's a whole new structure to the will and a different way of thinking, then I don't think a codicil makes sense. Then just create a new will and revoke it. But ultimately it will be your client's instructions. And I suppose there's just more than one way of dealing with it. Eh?
I think also the second question which I was reading up today, I think is looking at, I think maybe I'm speaking ahead of your lecture, the living will. I think when I read the original will today, going to some wills, people make, I suppose testators, I'll call them, making a note of a funeral clause where they state where they want to be cremated or buried, where, in which area, etc., depending on the birth or the roots. And the body remains must be given to specific institutions. I'm aware of that. If you look at the living will, they also speak about the body remains, and they also make giving permission to family members should one get sick. When you deny medical treatment, you don't want medical treatment. You don't want to be put on life support. You don't want to live. But obviously, they don't kill you because it's not allowed in our country. We'll take medication until such time one person goes. So why have that a living will when we can embody this clause, those clauses in one original will? Is there a need for that?
You one evening ahead. Living Will is going to discuss tomorrow night. But yeah, I will discuss it. But I hear your thought process. But there is a little difference, just a little difference. But I'll touch on that tomorrow night.
Thank you, Advocate.
Perfect.
Hi, Carl.
Evening.
Okay, all right. So yeah, let's do 4 more questions because I think I heard like 4 people there. So go for it. Doesn't
Yes.
matter what order.
Okay.
Okay.
If I can start, is it okay?
Yeah, go for it,
Yeah,
sir.
you
It
can
doesn't
start.
matter
It's
what
fine.
order.
Okay, Felix here. My question relates to how we calculate the monies when it comes to a collection clause. Supposing that in 2015, I gave my older son 500,000 and there is no clause for collection in the will, and then I die in 2023. Obviously, if there is enough money in the estate and you want to set aside the 500,000 in order to bring the younger one on an equal footing, it's not going to be fair because the 500,000 in 2015 is different, it's of a lesser value in 2022. So my question is there a way to account for that difference in the value of that money when we're doing a collection?
Most definitely. That's where you'll often find actuaries. I don't know if you're aware of an actuary. So, you know, they obviously quite a tough degree to do at varsity as well. But they are brought in a lot of times with deceased estates, not just to calculate collation and things like what you just mentioned, but also future maintenance and things like that. So they'll be brought in as a professional to determine the value of that today and to set it aside accordingly. So you might need to include an actuary in your calculations and appoint them to help you figure out what is actually the value that the one benefited more than the other.
And they're expensive.
Yeah, no, they're not cheap.
Thanks.
Yeah.
Okay, can I go ahead?
Go for it.
Okay. I just want to ask about the usufruct, you know, the right to enjoy. Can you put a limitation clause to say you have right to use maybe for the next coming 5 years? Is that allowed? And another thing is, if the person who's got the right to use passes away, can they bring another person to actually finish whatever limit that is left in terms of the use of the property?
Okay, so first of all, yes, you can, with the usufruct, it doesn't have to be over a lifetime. You can indicate that it is for a specific time period. So yes, you can do that. And secondly, a usufruct can't pass on. So if a usufruct passes away, it ends. There's no supplement to a usufruct.
Okay. And what if the owner of the person that has given the right dies? It continues with the next owner, or does it also cancels out?
No, it continues over the usufruct's lifetime if it hasn't been limited.
Okay, all right.
Cool.
Yeah, can I
Can I be next?
Yeah, so I heard that lady earlier, so let's do her, and then there was a gentleman who came up. So let's go that way, the lady and the gentleman. Go for it.
Okay, thank you. My name is Emily, and I have a question. Is it in violation of the freedom of testation to advise a client as a legal practitioner to include in their will
the undisclosed illegitimate children if they weren't mentioned with precision.
So Emily, you broke up there. I got, you know, if you can just repeat that. There were only portions I got. I heard about illegitimate children, but you broke up for a second. Can you just repeat that question?
Okay, is it in violation of the freedom of testation to advise a client as a legal practitioner to include their undisclosed illegitimate children if they weren't mentioned with precision?
Look, it's not in violation, you know, but you've got to be careful on your wording. So if your will specifically states by name, you know, who should inherit, then that's what we do. We go by name. But if it says children, you know, all your children, then obviously that will include everyone. You know, it doesn't matter whether legitimate or illegitimate. You know, at the end of the day, you can advise your client as whatever it is, but your client must make the ultimate decision of such. And they're not capped in their thought process. They don't have to benefit every child equally, but they have the right to do so as well if they want to.
All right.
Cool.
Okay.
Okay.
Okay, thank you.
Thank you. Okay, sir, go for it.
All right. Sorry, sir. I need kudos is the name. I need clarity when it comes in community or property.
Yeah.
And one of the spouse, let's say the wife, decides to approach an attorney to make a will. It's not a joint will, but only the wife, not with the husband. And eventually, the wife passes on. Such will, is it valid or is not valid? Looking at the fact that they are in community or property. Yeah. I need clarity on it.
Yeah, so it's 100% valid. I mean, just your marriage regime and your will is two separate things. So you're entitled to do what you want in your will, but just keep in mind that your marriage regime is ranked higher. So let's say you are married in community or property, you and X, and X has a will that says when she dies, everything's going to go to some other people. Okay.
Okay.
Keep in mind when she dies, half of everything she owns is yours because of marriage. So whoever's appointed in a will to inherit, they're only inheriting after you've taken your cut from the marriage regime. So yeah, you can say what you want in the will, but the marriage regime is ranked above the will. So you'll always first have to comply with the marriage regime before we look at your will.
Okay.
Yeah.
Okay. So I'm a little bit confused in the sense that if in community or property and there is no will, for instance, the wife died intestate.
Mm-hmm.
She definitely she's not going to inherit. It's only the husband and the children who inherit. Now, and then in other way, you said if there is a will and the woman passes on, what happens? Because when there is no will, the property, the estate devolves among the husband, the surviving husband and the children. Now, but when there is will, you are saying that whoever that she mentioned to be a beneficiary in the will still inherit. Which of the half would the will be talking about? Why the woman is already deceased?
So remember, if you married in community or property, effectively you have one estate, eh? One estate with your husband and wife, you know. So if you die, you own half of the estate if you married in community or property. So if you say someone else must be the beneficiary, then they're the beneficiary to your half of the estate. The husband would still keep his half of the estate. So whoever that person is who's getting the wife's half would depend on who the wife appointed in the will, you know, as the beneficiary. Yeah.
Okay. Okay.
Yeah.
Correct. At least
cool.
I'm okay. Yeah, great.
All right. All right. Ladies and gents, I think we've progressed quite nicely this evening. We're pretty much almost done with testate law. One or two other things I want to discuss with you tomorrow night. I mean, the living will was brought up, the codicil was brought up, as well as a testamentary trust. I think it's important we have that discussion. So we'll talk about those couple aspects and then start with intestate law tomorrow night as well. But I think for the first evening, we've covered quite a lot. So ladies and gents, like I mentioned, even tomorrow night, if you have a question regarding tonight's lecture, please ask. As you've seen, I try to get through as much questions as I can, and somewhere along the line, you will have your moment. Right, from my side, have a good evening, and we'll be back tomorrow. Cheers.
Cheers, guys.
Yes.
Thank you,
Thank you.
Bye.
Bye.
Good
Guys, there's a lot of links there. I'm not sure which one is which. Can somebody just direct us to the right WhatsApp group, because there's a lot of links that I saw.
Join all of them.
Just add your numbers. Add your numbers, people will add you.
Join everything.
That's simple. Add yourself to the Republic. Add yourself
Join all of them, and then you'll
to
see
the
the one with
Republic,
the most.
not to the democracy.
Sorry, guys,
Alright,
why is the WhatsApp
thanks,
group?
See you tomorrow.
So far,
Bye, everyone. Have a
so
wonderful
far the main
evening.
one seems to be the one with the second intake 2022 UNISA. So Lira Vialo,
Tomorrow, guys.
Unisa
Add your number and then add you to the group.
Guys, I think the
Hey,
one.
you know,
Yeah.
UNISA 2022 intake.
PBT contract, hopefully.
Guys, before you leave, can someone please tell me how does this program actually works? Because it's like we are not being informed of, like, with regards to the assessments and everything. Can someone please take me through what's really happening?
You must click the link.
You know what you should do?
Click the link. Look
Last
at the
week,
announcements.
you know this. It was 2 weeks ago. There was an introduction lecture. If you go listen to that lecture, everything has been explained. There's even a timetable of how the lectures are going. If you look at that, it will show you. I know the first assessments are in October, I think.
All right, I thank you so much.
Don't forget to get ready, guys.
Nassir.
Next on the 9th.
Hello, guys. Hi. Before you all leave, I just got one small request or assistance. I see there's there's something that I'm not sure of. It's a CCP lecture, and there's one more stuff that I'm not sure of. I think it's something about to do with something. I'm not too sure where I wrote it. LAPM. LAPM. What is LAPM?
Legal practitioners
On the
accounts
emails
management.
that they send.
According to the program, I was looking at one of the modules there, which is not in our study guides at all. It's called CCP. So I don't know whether the guys, anyone can tell me what
Constitutional court.
CCP
Constitutional
lecture
court practice.
and LAP exam. So I'm going to send an email to our coordinator to ask them to explain, because I think some certain things are not clear here.